Today I have with me a man who needs absolutely no introduction, Justice Sanjay Kishan Kaul, been a judge since 2001, first appointed as an additional judge at the Delhi High Court, then in 2017 became a judge at the Supreme Court, and the author of various important judgments, the recent ones being in fact the Kashmir's 370 and also the same-sex marriage case. So welcome to CNN News 18, and what a splendid career, first at the bar, then at the bench. What are the plans next?
Take time off, relax, do what I have not had time to do. So first priority I feel is to spend more time with my grandchildren till they don't have time for me as they get to school education. Spend a little time on my health. I think that is some kind of a priority because I love traveling, and if I have to travel, whether in my bucket list or in the country or outside, then I should take care of that. Spend more time in Kashmir, where I'm doing some things, and do things which like reading beyond law, see more films, see more plays, try to pick up golf again, broadly this, and then do a little bit of legal work to keep my mind occupied with it. But I don't want to get drowned in that. That's the only thing.
So a lot is talked about judges taking up posts post their retirement, being governors, being appointed as chairman of various committees or councils. Any plans for that?
Doesn't fit into my scheme of things.
Another thing is that you were the second senior most judge after the Chief Justice of India. You were in fact the senior most judge. Not only that, you were a part of the Collegium itself, but a lot is being talked about the Collegium very recently. In fact, debate sparked up in the last few years with regards to what is better. There was an NJAC that was brought in, but the Collegium system still exists. But many questions are raised on the Collegium. Do you think it needs a rework? There should be some changes that should be made to the Collegium system or the judicial appointments.
See, the Collegium system came into being in 1990. It had a purpose. It has operated fine. But the political spectrum thought that they wanted a greater say, and they were not comfortable or not happy with the system of appointment of judges through the Collegium system. They brought in a law. Now that was struck down. So the challenges to the Collegium system working have really come post the NJC judgment, because the political dispensation has not, over a period of time, been really able to accept it. They feel they have a role to play, and when there are dominant majority governments, they all the more feel that they should have a bigger role to say in the appointment process. Now, Collegium system endeavors have been made to tweak it, improve it. Different methods were thought of, and many people have contributed towards it. So, when I came into the Collegium, I thought that it is necessary that judgments of the judge we are considering must be circulated. Formerly, there was no such process, but it was accepted, and since then, those are there. So, I thought that's an objective method of seeing. We know the judge, we may have seen some of his judgments, but let's have a holistic consideration vis-a-vis other people. So, who has to be considered? Circulate the people who will come in the zone of consideration. All that has been implemented. The question is whether the political class is comfortable with the Collegium system. That seems to be a little problem. But the current law is the Collegium system. Therefore, my belief that till the Collegium system continues, which is the law, then it must operate as envisaged, which envisages sending a whole spectrum of scrutiny from the recommendations to the government's view, to the IB's view, state view, consulting judge's view, then the Collegium considering, and the number of people who pass through the system and ultimately are recommended by the Supreme Court are not even 50% of the total number of names which really emanated. Now, the problem starts thereafter if the appointments do not come through. Government has the right to return the names once, and the court can reiterate it or accept that view. So, when names are just detained and neither appointed nor returned, I don't think it's the appropriate thing to happen. There are of course some cases which have remained as second time reiterated, number about 4. 13 names of different vintage are pending, which have neither come back nor appointed. Similarly, a problem about which should not have arisen is transfer of judges. 6 names are pending. 3 Chief Justices recommended for some time are not pending. 5 more vacancies have arisen for which no collegium has been held. So 8 acting Chief Justices is not a very happy situation. So some speed is required in all these appointment process with reasonable period of consultation. And the judgment of the 3 judges bench headed by Justice Bobde, with me a party to it, and Justice Suryakant, have mentioned the timelines within which we expect things to be done. Whether NJAC should have been struck down in this manner is a legal debate. My personal belief I have expressed before is that it got buried before it got a chance. So, would it be better to keep it pending for some time and see how it operates? That was one method. Second method was to tweak it. I believe it can be because when you are testing it on the parameter of constitutionality and whether it meets the norms of a basic structure doctrine, the predominance of judiciary was what was envisaged, and one of the major troublesome aspects was a 6-member committee instead of a 5-member committee. So, could the Chief Justice have been given a casting vote? These are all aspects which can be debated. Maybe we are wiser after in the hindsight, but the solution is what? I don't think many things can change in the collegium system now. What was required or could be improved has been done. Now, the second aspect is only appointment. Now, if there is a problem, if the government perceives that it wants another system, then they'll have to bring a law in consensus and in the context of what the court observed while quashing the NJAC.
Another thing is that we're talking about judicial appointments. You were handling that particular case, and by the end of it, we saw that the case was not listed before you. There was a kind, people were questioning that calling it a listing controversy, in fact. But do you think that, in fact, you had certain observations to make? You had been handling that case for a very long time. So, I mean, was it kind of unfair or something like that, the case being transferred?
So, I was a party to the 3 judges bench, and that is why the case must have been assigned. Somebody must have assigned the case to me. I did not assign the case to myself. And from time to time, I passed various orders. In fact, those orders arose from an application file, which was for contempt. But then we had issued notice not on the contempt, but try to carry the debate, and so that the Attorney General appears and we see how this can move forward. I would have done maybe one more sitting, not more than that was possible within the time frame. I wouldn't like to comment. Chief Justice is the master of the roster, whether it appeared, did not appear on my board. And I'm sure somebody else will carry the way forward after that.
So, you had given a very extensive judgment in the 370 case. The case though was on constitutionality, but your judgment brought a humanitarian angle to it. It was the plight of the Kashmiri people who faced those violent times in 89 and 90s. You asked for setting up of a Truth and Reconciliation Commission. Do you think that isn't it too late for that to happen? It should have happened at that point of time itself.
I believe this is the time. If it has not happened before, it should happen now. See, in South Africa also it took many years of turmoil before it was established, because by the time they got their independence, that is how it was. So there are 2 aspects to this. One aspect is the circumstances in which a large section of population, more than 4.5 lakhs, was compelled to migrate. And that issue has never been addressed, I believe. Nobody tried to get to the bottom of it, why it happened, and it was brushed aside. Then you had the army coming in, trying to fight a war. And when the army fights a war, paramilitary fights a war situation, things happen and did happen. So there's another section of society which lived there, which has some grievances. It arose recently also some problem. So Truth and Reconciliation Commission objective is that if you are saying, well, it's too far in the past and now we can't provide a judicial remedy to it, or criminal remedy to it, at least acknowledge something wrong has occurred. That acknowledgement itself is a healing process. So, and that's how it worked. It worked beautifully in South Africa, where people, I've quoted on aspects where people cried when they heard what had happened. So things may have happened in the heat of the moment, but the least I would expect is an acknowledgement that things went wrong. One, things went wrong earlier, things went in 89, 90, things went wrong even thereafter. Therefore, I've talked about excesses of non-state and state actors both. If this is accepted, it will be a healing process and help in people coming together and peace to the state, which is what everybody wants.
Definitely. Another thing is that, recently the Supreme Court basically passed in a high-profile case. It was a bail matter. Though the oral observations were a bit different, they didn't seem to, reach that finality. As a judge, you've been a judge for almost, more than 20 years. Do you think that these oral observations at many times do not reach the final verdict, and basically people take it otherwise? So how do you comment on it? How do you see that happening?
So oral observations at times are endeavors by a judge to elicit responses, to give a quietus to what may be in his mind and come to a conclusion. Now, one option is the judge sits quiet. Okay. The other option is a very talkative judge. Both extremes are not good. If a judge keeps quiet, the lawyer never gets a chance to know what is troubling his mind. I, as a lawyer, would be very uncomfortable with a completely quiet judge. Similarly, the judge is not a lawyer. That's what we are taught and we slowly learn. So, in this process of asking questions, it is not necessary that is the view. View is what is finally formed. Now, what is happening today with the glare of the media, glare of various systems, access of people to the inside of the court, they sometimes may tend to form opinions on the basis of questions. That's not how a judicial determination can take place. I am not commenting on individual cases, but on a process which must be carried out. This is part of the opening process, I think, because as in the courtrooms, the public has come into the courtrooms in a sense. Constitutional matters are telecast, other technology is being utilized. So queries will arise and it will take a little time for people to understand how the court system works. At this time, it is only quenching the curiosity which is occurring.
Sir, times are changing. You were an author to the privacy judgment, and we are in times where artificial intelligence has taken over. There is a lot of debate about deepfakes, and since you've practiced on the original side, the civil side, do you think that such vast, development of technology and things changing so fast with deepfakes, there should be a law, there should be a regulation that should, prevent things from happening? We saw that very recently, actors, a deepfake was created, and that spurred quite a trouble. So, do you think that that's something that needs attention?
So technology has always had two ramifications. One is the positive ramification. We've seen that operate in technology. It's extremely useful, whether it's virtual hearings, there's hybrid hearings. That's the positive aspect of it. Getting rid of very bulky files in huge matters, because everything is, soft copies are available. Second aspect, as you say, is of deepfakes and others. And in the context you talk about of the privacy. I believe privacy is a very important part of a person's rights. 9 judges held it to be a constitutional right. Now, having said that, we were conscious that it will play out. We can't determine what all is privacy, what all will be violation at the threshold. All of us were conscious, I think, of it. And it will work out over a couple of years. This technological growth is a matter of concern. Well, let's look at a simpler method. People take photographs, they can be morphed. We as judges are prone to it. I mean, I go to functions at times. The selfie craze is so much now that people will just come, take a selfie. You really can't stop it. I have been sitting with, say, the Chief Justice, somebody will stand at the back, and I can see another person taking a photograph, and I turn and somebody else is taking. So, these are smaller examples. Now, if somebody changes the photograph, does something else, So these are concerns, but then we'll have to learn to deal with this. People should be a little more skeptical instead of straight away, attributing negatives to a person in view of this technology, and regulation becomes necessary. I do believe regulation is necessary to prevent such scenarios from occurring.
So recently, when the debate was happening in the Parliament over the Chief Election Commissioner's bill, the Supreme Court had passed a judgment where it had asked for inclusion of the Chief Justice of India. The government brought in a bill where the Chief Justice was removed from that particular aspect, and Vice President Jagdeep Dhankar, while Raghav Chadha was actually quoting from the Supreme Court judgment, said that the judiciary should not enter into Parliament's domain. Making laws is exactly the domain of the Parliament. So, is there, do you think, a rift that exists continuously between the judiciary, or where actually this should start?
So, we have a constitutional scheme of first past the poll of a democratic system. There are many other aspects of democratic system. There could be a proportional representation, there could be many other methods of it. We chose this method. And therefore, I believe the constitution makers also brought in a check and balance by giving judiciary an important role as one of the pillars. No doubt it is not the job of a court to make law, it's a job to interpret law. It can fill in vacuum. That's what the earlier judgment did. In absence of law, it filled in a vacuum. Government decided to bring in a law. Now, the composition of the law, of the committee selection committee, in a sense, is the prerogative of the Parliament. Now, it may be said that it performs such an important role that there should be a more objective consideration by adding an independent person, Chief Justice or somebody else. But that's not how the Parliament decided. Now, Parliament is a place for debate. It has to go by majority. So, if there is a consensus in Parliament or larger consensus enough to get a law through, then that law can only be tested on the touchstone of constitutionality. This is the practical problem of it. These problems are a little more when there is there's a dominant government in power. In coalition governments, there is a better balance. In a dominant government, the government in power feels that it has in a way, a higher mandate of the people, and therefore the right to formulate laws in the manner they deem proper. So, this little bit of, it's not friction, but this difference of perceptions is something which will continue. In fact, it's not unhealthy also, I would say. Justice Sabharwal once, former Chief Justice, whom I had a very good equation with, once said, see, a little bit of innate tension is good for the system. If things are very hunky-dory, there's a problem, reverse problem. That's the working of the system. I'm not really concerned how it is perceived as, is it an executive versus judiciary? No. The check and balance system on the executive by the judiciary will create some element of tensions.
Similar happened in the Delhi Services Bill also. The Supreme Court passed a judgment, and then the government brought in a law. So that is a constant process.
That has been for the last couple of years. Delhi has a peculiar problem because it's the capital, and the constitutional structure in such is a little different. There's a constant debate between the two people who are supposed to share the power and what matter that power has to be shared. That's the problem.
Another issue that crops up, at least in these times of social media, is judges are criticized for their judgment. People say a lot on social media that this judge is that judge is this. Do you think that this should stop, or there should be a regulation on this, or what are your views with regards to judges being criticized?
See, it's criticism is part of a democracy. Healthy criticism. Now that the social media has created another avenue of it. I think it's impossible to control it. I faced it. Praises also, criticisms also. So both ways it operates. I'm not on social media for that simple reason, because it doesn't help in trying to listen constantly to it. The whole concept, I think, arises from everybody having an opinion on everything. The social media permits you to express an opinion on something you may know nothing about. This is, I believe so I will say this, and you don't control it. It's a reflection of a system where people don't want to listen. See, what is the casualty today? Everybody wants to talk, everybody wants to speak, but nobody wants to listen, and nobody wants to listen to how a particular system works. If a judge starts deciding how a medical profession would be run, there would be a problem. Similarly, a person not familiar with the working of the judiciary, similarly will not be able to accept it. And every judge is a human being. He comes has bound to come with certain baggage. And his training teaches him that the baggage should be minimal. So he should be able to dehorse his political thinking and other thinkings, decide cases in accordance with the settled established law. No two human beings can be identical.
You were dealing with the Gyanvapi case. You had an opportunity to go into the Place of Worship Act as well. There has been a constant debate that whether or not the POW can actually allow for a reconsideration of a religious characteristic of a particular place. And it's not only one, but a lot of places where this act is now being pushed into, that there are, whether it's the Krishna Janmabhoomi case or the Gyanvapi case. But there has always been a controversy. But on a larger scale, can courts actually go into giving an order, going a little forward, giving an order to demolish a particular structure and allowing a different one to be built?
So, from a personal note, what came before us was only the cases being withdrawn by the High Court for expeditious decision and the complexity of the matter, which is permissible. At one stage, the counsels appearing for the petitioners had agreed to the concept, but they wanted it fine-tuned. Some other petitions came where they said, no, we don't agree to that. And so I had to list it for hearing on the aspect, a larger aspect, whether the High Court could have called for the matters and decided. Now, these are all socio-political cases, in a sense. There have been established institutions existing for a long period of time of religious beliefs in a particular place. The contra belief exists that there were some special monuments or place significance to a particular religion at that particular time. Therefore, it becomes a difficult task at times, and the court has to perform it in a legal manner. The ground reality is that in any society, and that's true of India also, when invasions take place, the invader seeks to destroy the existing culture and establish his own. That's a general ground reality. So you can't say things had not happened. Now, where it happened, what it happened, whether it's worthwhile touching up an issue after so many years, to some extent becomes a political decision, and to some extent it has a legal ramification, becomes on the rights which are there.
So, last two questions before I actually let you go. One is that there are various cases where judges actually go into depth, they pass judgments, but people come and challenge to it. They do not get a particular date. With regards to pendency, I'm going into, there are various cases which are pending before the Supreme Court, and many questions are raised basically on long vacations being taken by the Supreme Court or High Court judges. So, do you think that is a reason for that? And people don't really understand why these long vacations are actually there. So, what's your?
Somebody has to understand how a legal system works in any country. So, is it that we work less than what in different parts of the world? It's a categorical no. Australia, they work for 2 weeks, take off 2 weeks to write judgments. So, it's half and half almost. Singapore is 1 week working, 1 week writing, 1 week to improve your skills, because it's a mind issue. American court decides 100 cases in a year. So, the system works in a manner worldwide for a legal system where there is time off to think and write, because it's not a mechanical issue, and it affects the rights of the people, affects the lives of the people in many manner. I've always encouraged law clerks to come, students to come and sit in my chambers to just understand how a judge works. The Supreme Court working is tough, there is no doubt about it. There is no weekend. People have weekend, there is no weekend here. Because Monday is a miscellaneous day, you start reading on your Friday, Saturday files. In fact, in a high court, one could still try to get off a Sunday because they were different. Here, even that doesn't occur. Now, vacation, is it vacation to just travel around? How much time is spent? Because you really don't get time to write a longer judgment or a thinking judgment, even over a weekend. You may pen down an order, that's fine. Sometimes you pen down an order in court, sometimes in chambers. So you are, the vacation or the shorter vacations are often utilized for purposes of penning down judgments which are awaiting. That's part of it. It's not like sitting at home. So I believe it is non-understanding of the working of the legal system, which is the problem. Honestly, if a judge has to work X number of days, and you say that the judge can take off time whenever he wants and work that day, there would not be a problem from judge's point of view. But the bar would not accept this. It would be very inconvenient for them to work. Let's see, in vacation time, you say Supreme Court, there are vacation benches, they sit, old hearing appeals are put up. How many people come up for those old hearing appeals? So it becomes almost a second to next futile exercise to do so. I think the solution lies in better management of the court systems. At least when the case comes up, it should be heard. So I have always felt that, looking to the cost of litigation, we should post as many cases that can be handled. Now, if there are large number of cases, some attention will have to go to the normal routine Ramlal versus Shamlal case, which is called. There are cases pending in the Supreme Court. It's a matter of concern. In this high-profile cases struggle and the time taken by them, often we lose sight of the smaller cases which needs attention. And a lot of them, I think, need to be touched, and they will go. Either they'll fall by the wayside, or some smaller solution is possible. I found that at least in civil appeals, because civil appeals were my subject, I asked these old appeals to be posted before me so I can deal with them. Similarly, there may be specialists on criminal sides who would do it. So we did finish matters, but the total filing and the pendency is an issue which keeps on persisting. I think some attention to the older cases are due, which may help in coming to realistic areas of what we face. For a lot of time, the issues of cases remaining pending without removing of defects, etc. So there are many ramifications of what is a pendency. Pendency really, to my mind, is when a case is not being able to be attended to in a reasonable period of time within which it should be decided. But the case must be properly registered, notice issued, processes followed. So there are multiple reasons why the cases are pending. And both the bar and the bench have to cooperate in this to see that we come out with a better result. And this is apart from the fact that I think there are just too many matters coming before the Supreme Court over issues which need to be left at a high court level, merely because we may have a different perception is not good enough ground to interfere. And except where personal liberties are involved, it's very difficult to say that we will not interfere. And norms may be required, informally norms be created, because 136 is wide, where the Supreme Court should be circumspect in getting into it. As it is, I feel the dismissal rate is over 80%. So, but 2 days, Friday and Monday, are really in sifting through these matters. You have to read them, sift through them, and do so. So, in the American system, I believe all this is done in chambers. The law clerks prepare the note, and unless at least 4 out of the 9 judges feel that this matter needs an open hearing, it is shut out. In our system, there is a lot of emphasis on open court hearing and prolonged hearing. So, I think the lawyers will have to learn to argue in a smaller span. This load of case law which is creating a trouble needs to be controlled, and we have to learn to write shorter judgments so that person sees the decision on his list rather than any theoretical enunciation.
So the government brought in the 3 criminal laws have completely been changed, with almost a large chunk of the opposition leaders under suspension from the Parliament of India. What do you think that was it something that a debate should have happened in that, or there should have been a better discussion had there been opposition leaders there? And secondly, how do you feel about these criminal laws, because they are coming in not only as a general person but also as a lawyer, because it might completely change the legal curriculum?
So, well, I have not had an opportunity to really study the law. I've read about it. When such a large change takes place, it's going to generate litigation. I'm not aware whether any litigation impact study has been done as to what would happen with the change of laws. That's a little concern that, do you need to strengthen the systems? Do you need to increase the number of judges to handle it? Because after a long time, such a drastic changes are taking place. I'm given to understand a lot of them are also incorporations of the past law in different sections. And importance of properly drafted laws cannot be diluted. So, personally, I believe the Indian Evidence Act was a very, very nicely worded act, very nicely done act. If it required changes today, then it should be equally well enacted. Legislative drafting, absence of proper legislative drafting creates problems in terms of possibility of litigation. Yes, I do believe these are laws which needed to be debated. Unfortunately, the Parliament has seen a scenario where it is for the parliamentarians to see whether that agitation, consequential expansion is more important, or such important lawmaking acts coming into force need to have their assistance in the debate.
Thank you so much for speaking to CNN News 18. It was a pleasure talking to you and insinuating on a lot of topics and a lot of issues. Thank you so much.
Thank you.